Right, so here's the motion made by the prosecutors again. I forget the date that their motion to have my videos removed from YouTube was submitted. This is August 23rd. They even have the time. My public defender did not give this as a document to me over the email. She says it would cost, if I wanted to get this in paper form like I have it right now, it would cost me 10 cents per page. But I got this at they're called clerk of courts, and they work directly for the judge. So this is the motion to have my bond increased and me being put back in jail. So Matt Karzen moves that I have my bond revoked and requests that I get put back into custody by the state, and then re-released after I pay a certain amount. And then this is that they attached a verified application as required, hereby incorporated by reference. Okay, and then Alexander Jennings wrote it. So then the next page, you could see this first page, it's me as a defendant, and then the next page, it's Matt Karzen as a defendant, all in bold. The submitted again. Okay, and then they go into more detail in the second page. Increase bonds. People's verified application to increase bonds pursuant to this order. Sorry, it's Jennings. Says that she's a deputy district attorney. I was arrested July 27th in Hayden. Okay, and then I entered a plea of not guilty. Trial set January 3rd originally. The defense arraigned on 2 days later the benefits of personal recognizance bonds. I was arraigned and given bonds, and Jennings said that she objected because I don't have any ties to the community, and I have an active YouTube channel where I have a history of enraging law enforcement, and I'm a danger to the community. I began on August 23rd. I began to live stream a video on YouTube at 1:30 p.m. This video, it states, if it gets like under 0, I'm gonna have to make a run for it. I don't think I'll be able to handle it. And then she carefully typed out the address, and then the title is the reason why I removed 6 videos on YouTube. Alright, the video is still being live streamed at the time of this. So while she's watching the video, she's typing this up, I'm guessing, while she's watching the live stream. My trial is currently set for the middle of winter season. As the judge is aware, it often gets below 0 degrees in the fall and winter months. The temperature can occur sometimes even as early as during the month of October, as seen on WeatherSpark. I've never checked out WeatherSpark before. The defendant has made other such similar statements in other videos on this same channel, noting things such as running would be preferable, but he doesn't like the consequences of having warrants when he does that. The people reiterate that I am a flight risk, and that the benefit of the bonds, the $1,500 bond, should be revoked, and they should issue a warrant out for my arrest. Word for your okay, Jennings respectfully requests that a warrant be issued for the arrest of me, and that I appear in court immediately for a hearing to increase my bonds. So they put out a warrant for my arrest. The cops come, pick me up, throw me in jail, and then I have a hearing to increase my bail to get out of jail. All right, and this is true to her worst personal knowledge and belief. Her worst beliefs, pretty much. All right, and then it's it. Certificate of service. I duly provide a copy to the defender, the public defender. She's done that. And then I got a couple other things here. The public defender's response. Kiyomi Blick got her email. Notice of objection to the court issuing a ruling before defense counsel responds. And now this was when I had 12 hours to take down videos. She put up defense counsel hereby moves this court not to issue an order on the DA's motion to increase bond until counsel prepares a response. I object. Earlier this week, the court granted a motion filed. That's the 12-hour motion by district attorney, and we were not allowed to respond. We had 12 hours. I had to take down the video. I could not respond to that. All right, so it was a little unfair, a little dirty DAs at it again. All right, and then this is a separate deal. I'm just throwing in here. All right, I requested to have some media. They call it expanded media coverage. Okay, it's just media coverage. They're just being dumb about it. All right, I just wanted to audio record the hearings, and the judge, he's a salesman. He's a businessman. Cause look at how this is. He's a church. He's like a church man. This is a church answer. Okay, he denies it. He denies my request to record, and he says, church. This is from the pastor. Recording for personal use is never allowed. That's a pastor response. And then the business response, the defendant is free to order for $50 of an, I don't know what ant court is, proceedings. Should he desire? No, I do not desire to pay $50 for that. So these people are really dirty. Even the judge is dirty in his own way. In his own ways. The DAs are dirty in their own ways. The judge figures out how to make the money. The DAs figure out how to screw you over. So just recording that.